Nathan, BSA has some implications for responding to information requests. Can you tell our audience about that a little, please?
Sure. What we're talking about is when law enforcement asks a credit union for additional information related to a SAR. Generally speaking, when a federal agency asks for private information about our members, credit unions must require that the federal agency comply with the Right to Financial Privacy Act by either providing a member authorization or a document related to an exception under the law. However, the Bank Secrecy Act permits federal agencies to obtain information related to a SAR without following the compliance requirements of the Right to Financial Privacy Act.
So what kind of information can a federal agency request related to SAR?
These requests need to be narrowly tailored to the scope of the SAR and specifically identify the financial records, documentation, or information required. If the federal agency request is too broad and is determined to be outside the scope of the SAR, the credit union must require that the agency comply with the Right to Financial Privacy Act.
What if the request for SAR-related information comes from a state or, say, local law enforcement, let's say?
State and local law enforcement may request additional information from a submitted SAR, and a credit union may provide information within the scope of the SAR. Just as with a federal agency, if the request is outside the scope of a SAR, the state or local law enforcement agency must comply with applicable state law regarding privacy and information requests.
So Nathan, RTFPA is not applicable to state and local agencies, is that true?
That's correct, but state law is still applicable.
Are there any other questions regarding SARs or CTRs that a credit union might encounter during business hours?
If a CTR or SAR is incomplete, the IRS may contact the financial institution for the missing information. All SARs and CTRs are submitted to the IRS Detroit Computing Center, and the DCC maintains reporting systems that FinCEN uses to access reports. A credit union should comply with such a request as long as the information should have been included in the report at the time it was originally prepared and filed. Other requests are subject to the Right to Financial Privacy Act. Law enforcement might also request that a credit union continue operating an account when it could be of assistance to law enforcement agencies that are investigating possible money laundering or terrorist financing schemes. FinCEN has issued guidance on this matter and stated that the decision to maintain such accounts is entirely up to the credit union. Credit unions should weigh the risks of complying with such a request. If a credit union decides to cooperate with an agency's request to maintain an account, it should get the request in writing, make sure the request is issued by a supervisory agent or an attorney representing the federal, state, or local law enforcement agency, limit the duration of the request to no more than 6 months, and maintain documentation of such requests for at least 5 years after the requests have expired. Also, just because a credit union is cooperating with law enforcement doesn't mean it is relieved of the record-keeping and reporting responsibilities under the BSA. It must still file a SAR when suspicious activity occurs on the account.
Oh, you mentioned that a federal agency has to comply to the Right Financial Privacy Act. What does that actually entail? Perhaps you could walk us through that.
It means that a federal agency wishes to request financial information not subject to an exemption and outside the scope of a SAR. It must do so in one of 5 ways. First, they can do so by member authorization, administrative subpoena or summons, by search warrant, by a judicial subpoena, or by a formal request. In addition to one of these authorizations, a federal agency must also give the credit union a certificate of compliance, certifying that the federal agency has complied with the Right to Financial Privacy Act.
Are there any exceptions at all to this?
Yes. A government agency is not required to comply with the Right to Financial Privacy Act when a member applies for participation in a government loan, loan guarantee, or loan insurance program. The government authority administering such a program shall give the member written notice of the authority's access rights under this subsection. no further notification shall be required for subsequent access by that authority during the term of the loan, loan guarantee, or loan insurance agreement. When it is necessary for the government to use or transfer financial records to process, service, or foreclose a loan, or to collect an indebtedness to the government resulting from a customer's default. When the credit union discloses what is necessary for the proper administration of programs regarding the withholding of taxes on non-resident aliens, federal old age survivors, disability insurance benefits, and Railroad Retirement Act benefits. When the request is pursuant to the authority of the Federal Reserve System or the Federal Housing Finance Board to extend credit to the financial institutions or others. When the request is necessary for the administration of certain veteran benefits laws. When the request is pursuant to an administrative subpoena issued by an administrative law judge in an adjudicatory proceeding. When the request is pursuant to legitimate law enforcement inquiry and is seeking only the name, address, account number, and type of any member. When the request is issued by a subpoena or court order in connection with proceedings before a grand jury. When records are sought by the General Accounting Office pursuant to an authorized proceeding, investigation, examination, or audit directed at a government agency or authority. When a credit union or supervisory agency provides any record of any officer, director, or employee to the Attorney General, a state law enforcement agency, or Secretary of the Treasury, if there is reason to believe that there were crimes against the credit union by the insider. When the examination by or disclosure to the Resolution Trust Corporation or its employees or agents of financial records or information in the exercise of its conservatorship, receivership, or liquidation functions with respect to a financial institution. When the request is pursuant to federal statute or rule.
Nathan, that was really helpful.